Hi, this is Leah Binder from the Leapfrog group. We will be starting in about 1 minute.
I want to make sure you can hear me okay, right? I'm using my computer audio.
Yes, we can. Okay. Why don't we get started? Hello, everyone. I'm Leah Binder. I'm the president and CEO of the Leapfrog group. We are an employer-based organization founded in the year 2000 to improve the safety and quality of healthcare on behalf of American employers and purchasers of health benefits. Today is the third in a series that is hosted by the Leapfrog group of a series of webinars on the Consolidated Appropriations Act, the CAA for short. This is a very important new piece of legislation that is now going into regulatory impact. It was signed in 2020. And it is of great importance to employers. It represents a significant shift in the role and responsibilities of employers with regard to health benefits. So we wanted to ensure that employers are prepared and ready for the significant compliance challenges ahead, and also for the opportunities ahead as a result of the CAA, because the CAA was actually advocated for by employers. But the significant hurdle in front of us right now is compliance with it. And so I'm very pleased to have co-sponsors for this webinar series, including ERIC, the ERISA Industry Committee, and the National Alliance of Healthcare Purchaser Coalitions, among others, who have worked with us to support this webinar series, and I thank them for that. So today we are going to focus on the topic of pharmacy benefits compliance. This is one of the critical components of the CAA, which we now have some expertise with us to help us understand that, help employers understand what's ahead. It will include information on pharmacy procurement, spending, and reporting, which are all very complicated issues and made even more complicated through the provisions of the CAA, which again, really accentuate the fiduciary responsibility of employers with regard to a number of health benefits issues, but prominently including pharmacy health benefits. So let me tell you who our experts are today before I turn it over to them to give us the insights that we're all looking for today. Our main speaker today is Debbie Partsch. She's the Chief Pharmacy Officer for Innovu, and she will be giving us a broad overview of the pharmacy benefits requirements. Also talking with us today, just to comment from the employer perspective, is Annette Garisco-Files. She is President and CEO of the ERISA Industry Committee, also known as ERIC, which is a very significant advocate and player here in Washington, and had a leadership role really in advocating for this legislation, and now in helping and working with their membership of large employers to ensure that the legislation goes as we hoped, and also that employers are prepared for these challenges ahead in the compliance as we move toward compliance. And then finally, we have Mike Thompson, who's President and CEO of the National Alliance of Healthcare Purchaser Coalitions, also to help us understand and make sense of what's next. Now, this session is being recorded, and we ask that you mute to minimize all distractions. We encourage you to put any questions you have for the panelists in the chat. I'll be monitoring that, and toward the end of this webinar, we'll be able to bring forward those questions. Also, at the end of the session, take a look at the chat box for a toolkit, which we'll be posting for anyone who's interested in getting started with some of the issues that we discussed. We'll also have a survey, a 5-question survey, very brief, to get your feedback so that our continuing series is most relevant for you. All right, so with that, let me introduce Debbie Partsch, Chief Pharmacy Officer for Innovu. Debbie?
Hello, good morning. I think it's still morning, maybe it's afternoon on your Eastern time. I'm going to go ahead and share my screen with the presentation. Just give me a minute here to get this set up. Okay, so, I need help if we start at the beginning. Okay, ready. So we're here to talk about the Consolidated Appropriations Act. So I work for Innovu, it's a data, we offer a data platform and some solutions to look at human capital risk data. We're partnering and very similarly with Leapfrog and looking to find ways to reduce waste, create material savings for employers so that plan participants and their families can live a happy, healthy, financially stable life. And so the Consolidated Appropriations Act is one of the focal points of the healthcare spending requirements that we're going to be talking about. So I'm going to start off first by just showing this slide. This is adapted from work done by Adam Fine of Drug Channels. He's been following the PBM industry for years, and I trended some of his statistics that he had on it. And what this is showing is how dollars are exchanged in the pharmacy space. We're going to jump right into this by just getting a general understanding of where does all of the costs that the patient pays for and the employer pays for at the time. Did my screen just go blank? Okay. Let's see if that, okay. Again, why that did that. Second screen, maybe that'll help. All right. So you can see this again, correct? Perfect, thank you. All right, so we have a $300 prescription. You go to the pharmacy. Who makes what off of that drug? So there are different stakeholders depicted in the pie chart. The manufacturer who made the drug makes about $170 off of that $300 drug. The wholesaler buys it from the manufacturer and distributes it to the dispensing pharmacies. They make about $15. The pharmacy that dispenses the medication makes about $6. And the PBM, and the PBM's role is to adjudicate the claim from the dispensing pharmacy. They also negotiate rebates and work with plans and employers on formularies and discounts. They make $103. These are all estimated again and trended from work from Adam Fine and from the Drug Channels. But you can see here that when you look at, as an employer, where you fit into this equation is primarily in this segment here with the PBM. So as a plan sponsor, you, depending on your contract that you negotiate with the PBM to administer those pharmacy claims and pay for on your behalf, those administrative tasks, PBM can either get a fixed admin fee or they can share in the transaction, such as sharing and rebates. So as a plan sponsor, you may get 100% of that $103, or you can get zero. Part of the entire reason why the Consolidated Appropriations Act has come into play is because employers and consumers don't know who gets what out of this pie chart. And let's take a look on the right at the bar graphs as a consumer, how this can be translated into how it impacts them. And the top chart is an illustration of someone that has a fixed copay. The bottom chart is an illustration of somebody that has a high deductible health plan. So an enrolled member is an enrolled plan participant. They go to the pharmacy to get their $300 prescription. They pay their $40 copay. The plan is paying about $250. And then sometime after the fact, generally, unless rebates are passed at the point of sale, they'll get a rebate check from the PBM saying this, based on this prescription, you're getting $103 back. In the bottom chart is someone that has a high deductible health plan. And many people that have high deductible health plans may never even hit their deductible in that entire plan year. Some may. Regardless, and let's just say that this is the beginning of the plan year, fresh new deductible. The employee goes to the pharmacy, the member goes to the pharmacy, they pay the full $300 for that prescription. The plan gets the rebate from the PBM of $103. What the government is saying in this legislation is that just like in the retirement industry, the plan needs to demonstrate that they're acting on the best interest of the plan participant. And we'll go through the reporting. The plan will now need to show how this money they received back, how does this $103 benefit plan participants? It's not saying you have to track this back to the specific member that had the prescription. We may get there someday. That's what happened in retirement. But the first pass is, how did these dollars that you received back from the PBM, from the drug manufacturer, benefit all plan participants in lowering premiums, or in some, is what the legislation is asking or stating. So as a fiduciary, that's an important concept that I think just to understand and set the stage, that the obscurity of all of the stakeholders and where all the money flows is part of the impetus to protecting the consumer, to make sure that they're not paying more than they should at the point of sale. So what we're going to talk about today is there's 5 different areas, kind of have them bundled a little bit here. But first and foremost, what is a gag clause? And do you have any gag clauses in your service agreements? Do you have the data required in order to meet statute limitations? Do your agreements include definitions that align with the statute? And do you have a formal healthcare fiduciary process, similar to what you may have on the retirement side with your 401k defined contribution plans? Okay. So why was this created? I think in that first example, and just kind of showing what an example of a $300 drug, you could probably surmise why this was created, and the great work that Eric and others have done in order to get this passed, that employers have been begging for this type of information. One of the main challenges was the lack of clarity in the plan sponsor as the fiduciary, and knowing that as a plan sponsor and based on ERISA, that the employer as the plan sponsor has to act in the best interests of the plan participants. And they define what that means. There are contracts that the plan has when you enter into with a TPA to administer your medical and your pharmacy claims. You have to have full access to that data. You have to be able to have pricing transparency, to be able to account for all of the services that are provided. And there will be aggressive enforcement of the Mental Health Parity and Addiction Act that was also embedded in the CAA. I know you had a separate webinar on mental health parity, so we're not going to talk about that here. We're really going to be focusing on the pharmacy and some of those pieces. To be able to even do the pharmacy reporting, the first thing you need to do is to remove gag clauses from your contracts. You need to establish that the reporting is going to meet those needs. You'll have to get disclosures of direct and indirect compensation from your service providers. And again, the last part about mental health parity. But again, we're going to focus on the first 2. Okay, so let's just talk about what a gag clause is. And I'm going to do this with a quick story. We have a 7,000 life large trucking company that's national. And their PBM would not that prohibited the employer from using any data sourced from the PBM, any of the claim data, any of the financials, in order to go out to bid and do an RFP. So the plan, in order to see if they were paying reasonable expenses, did an RFP and did a market check analysis based on the limited information that they had. because they don't have full access to their data, in order for this employer to substantiate that they're paying reasonable expenses, they have to benchmark the market every single year. For a 7,000 life company, or even a smaller employer or a jumbo employer, that's very costly to do a market check analysis every year. You're looking at a minimum of $15,000 to $40,000 as a fixed expense. You're also looking at all of the meetings and the schedules and the time and resource commitment it is to perform a market check analysis. And it's not sustainable. No one is going to switch PBMs every year, and the industry knows that. So the first and most important thing of a gag clause, anything that restricts an employer's full access to claim information, plan information, rates, fees, and an itemized list of who is making what money, anything that restricts how you use the data and what data you get can be construed as a gag clause. And the primary reason, or I shouldn't say, one of the main reasons why there was a delay in enforcing the prescription drug reporting requirements was the employer said, we don't have the data to report this. We don't get granular drug level rebate information. We can't report what you've asked us to report, and I'll show you those requirements. So the government came back and said, take this time to actively remove gag clauses. So they gave us a year to remove these gag clauses so the employers do get the data so that they can get the reporting that they need to adhere to to be compliant. So you'll see words about prudent spending of plan assets, being able to make a test to these. So very closely, the action item here is for every employer to make sure you've contacted your third-party administrator, review your provider agreements, not only that you may have as an employer directly with that TPA, but if you have, as an employer, contracted with a consultant or contracted with a data aggregator like an Innovu or somebody else, that those additional service agreements don't have gag clauses. And that's an important distinction, because many employers that I meet with and I talk with will say, I'm a trucking company, or I sell paint, or I make biscuits, right? I don't have the staff to tell me, interpret this claim data. I need to hire somebody. I need to hire subcontractors to do this for me. So if the TPA is restricting and putting gag clauses on your subcontractors, that effectively is limiting you from being able to make prudent decision-making for your plan participants. Okay, so the reporting is, while many are talking about the prescription drug cost reporting, it does encompass other areas other than prescription drug. It talks about being able to break out the costs by group and health plan, broken down these costs by hospital costs, your healthcare provider and clinical services for primary and specialty care, prescription drugs, and any other medical costs, including wellness services. Today, as I said, we're going to focus on prescription drug, but there are other components. What I will encourage you to do is when you look at your contract with the TPAs and you ask your service providers if there are gag clauses in their service provider contracts, make sure that you're getting full claim access to all of the financial information, all of the provider codes and service codes. So, and national provider identifiers, procedure codes, diagnosis codes, national drug codes for drugs, ingredient costs, all of the financials. Make sure you're getting full access to that information. So in the legislation, they delineated and they're categorized into 10 different reports. And one of the most common questions that I've asked is, my PBM or my TPA said they will do my prescription drug reporting for me on my behalf. Is that sufficient? I will say that the first 7 reports that are outlined, pretty straightforward, and that a PBM can easily do that. Your plan year dates, your number of enrolled beneficiaries by state, top 50 drugs, et cetera, et cetera. it's really the last three that a PBM is not able to do on your behalf. Because that goes back to that very first slide of that $300 drug. The plan needs to be able to demonstrate how rebates, coupons, and other remuneration, any monies paid by a drug manufacturer that are paid to the plan, whether the employer receives it or it's retained by a third party, have to be able to attest how those dollars are used to benefit the participant and the impact those dollars that are given back to the plan have on premiums. So this information is currently not available on the rebates. There's been some information more recently in November and some clarity that came out. Initially, the questions are, do you need to have it at a national drug code level, which is like a social security number for a drug, very specific. And the question came as, well, can we just do it and roll it up at a higher level? And the more I talk to a lot of those in the market, they're trying to aggregate it and roll it up more and more and more to try and protect the confidential nature of the rebates and negotiations to be able to compete in the market. I would like to make sure that every employer appreciates that that a PBM has the rebate information at the claim level, at the drug code, national drug code level, the NDC, because that's how they track it. That's how they know which member, which plan, which employer got which drug at what time. And that applies to this drug manufacturer rebate contract so that they can bill the drug manufacturer, get the money back in-house, the PBM gets that money from the drug manufacturer, and then they have to allocate it back to the respective employers. The only way to do that is to have it at that granular level at a drug claim level. So if PBMs are then doing reporting on this and saying that they need time to aggregate it and roll it up higher, an employer can easily say, that's okay, I'll just take the granular level that you have today. Give me a copy of that information. You may not get it. I may be living a pipe dream. That data, though, is needed. And that's where, at the end of the day, the government, the departments, they really don't care about the employer so much. They're putting this burden on the employer, but they care about the public and the average American citizen and being able to afford that prescription. And that's why they're putting this on the backs of the employers to get this level of information. So we're going to go let's go forward and talk about what is a drug rebate and what does a remuneration do. So one of the goals of this is for you to go back, an action item is to go back to your PBM and make sure that the definition of rebates and all of the definitions in your PBM or TPA contract align with the statute. The federal definitions are explicit, and it's defining remuneration as respect prescription drugs that are prescribed for an enrollee. They include pharma manufacturers, retail pharmacies, and other vendors. They give examples of chargebacks, rebates, cash discounts, free goods that could be coupons, grants, pricing concessions. So it's more than just what we historically or how rebates have been defined for us in the industry. It is a very broad set of disclosures. So at the end of the day, if we come back a year from now and I show that prescription of that drug and said, this is $300, all of us should be able to say, we know who gets what out of that pie, because that's what we're being asked to know. We need to know that all fees are part of that $300, what's retained, all of these side discounts or grants and things that are given. Everything has to be 100% the cost of the drug. You need to be able to then, the action item is to get a category and detail all of those expenses associated with that prescription drug. If you had to send a letter out, if you have to do COB, all of those expenses to administer the program need to be tied back to the cost of the drug. document why the fees are paid to the PBM, and that they're bona fide. So this analysis, you have to make sure that they're reasonable and appropriate. This is where the benchmarking comes into play. Easily performed or definitely performed in a market check analysis, but having an ongoing benchmarking solution and ongoing reporting solution will aid employers in this activity. So here, when it goes to rebate and the reporting itself, right, they must report how the fees are used to reduce premiums and out-of-pocket costs. The reporting includes payments that are made to the plan, they're made to the coverage, they can be made to administrators, and they can be made to your service providers. So a service provider could be your consultant. It could be, someone that does communication for me. Anybody that could be being paid off of these monies generated from this prescription need to be disclosed. And it goes into amounts paid for each therapeutic class of drugs and the amounts paid for the top 25 drugs. And so this kind of goes back to when I said those 10 different reporting elements that PBMs can generally do the first 7. While an employer can delegate or designate the PBM to do that reporting, it does not waive their fiduciary responsibility to justify that that information is accurate and complete. So if someone's just doing the top 25 drugs and an employer doesn't have a list of all of the drugs that earned a rebate, how do you know that that top 25 is accurate? So that goes back to trying to press and get the granular information so that you have it, that you have a copy of it. So if in the event you ever get audited, you can show exactly how you arrived to this reporting standard. And then, so requiring the disclosure, attestations, different action items for you on this piece here. So my final piece that I just wanted to mention, and I think we're doing okay on time, is that the reporting is actually due at the end of this year. You may hear that there's been delays. There's only been delays in the enforcement of different penalties and pieces like that. The departments, and this is a quote directly from the Federal Register that says, the department strongly encourage plans to start working on this now so you're in a position to report this information at the end of the year. So removing of the gag clauses is one, but the plan also goes back to, this reporting goes back to the plan year of 2020 and the plan year of 2021. So I want to press upon any employer that plan year 2020, the books are closed. So there should not be any delay to be able to fulfill the reporting obligations for plan year 2020. Plan year 2021, you may still have rebates trickling and that's not closed yet, but 2020 is. The second thing to keep in mind is if you are in a situation where you switched PBMs between plan years 2020 and 2021, or you're thinking of switching again, or you just switched in 2022, or you're thinking of switching in 2023, you need to get on top of this now because you have to get this information. And a large number of people that I know what they do when they negotiate, and I think that the toolkit that you'll be getting from Leapfrog will help you with questions to ask your TPA. It'll help you with language that you should put, that you could consider putting in your PBM and TPA contracts, that the TPA and PBM are going to help you with this federal reporting requirements. And with that language is in there, then it would be hopefully less of a battle to get this information in order to comply. So with that, I think that is my last summary, my very last slide I want to impart on you is where to begin. One, evaluate your procurement process that you have in place now. So if there is a lack of disclosure and transparency on how you're making your healthcare buying decisions, and there's a lack of data that you need, identify those gaps. What are your gaps and how do you fill them? Based on what you learn in your procurement process, you'll want to review all of your fees, your contract language, and make sure that those are structured in a way that you can substantiate that they're in the best interest of the plan and participants. And I encourage everybody to talk to your consultants and engage, an ERISA attorney. I know that Innovu has spoken with dozens of ERISA attorneys just to validate that our interpretation of this is on the right path, that this isn't something that's going away. This similar legislation revolutionized the retirement industry and cut out 2% of all of the the fees that resulted in hundreds of thousands of dollars to the beneficiaries of their 401k plans. And that is the model that appears to be followed by the Department of Labor and the governments that put out the CAA. But I'm not the expert. We do have the expert here, which is Annette, who worked with the ERIC group, and Michael, of course. And so with that, I'm going to turn it back over to you, Leah, if you would like to have any comments.
Yeah, actually, before I turn to, I think Annette is going to go next, but before I do that, let me just, we got a lot of questions in our chat, but there's a couple that I think we should just clarify right away, just before we move on. And that one question is, does this apply to self-insured as well as others? Does this, let me get the right question. This is imply, in other words, does this apply to all plan sponsors beyond self-insured? What about fully insured?
I don't believe it applies to, let me see. Annette, I may need you to chime in on this one. I think because this is under the ERISA guidelines, it really applies to self-insured plans. I think that, however, if you're fully insured, I think that it would benefit you to know how those dollars are still being used to offset your premiums, because the TPA is defining the premiums for your plan. And so I'll defer that. The other one I often get, though, is there are public entities like school districts that are not under ERISA, they're under PWSA. The provisions of the CAA do apply to them, with the exception I've heard from ERISA attorney, from different attorneys, is the direct and indirect comp disclosure for their consultants and service providers. However, even though that's not required, that just seems something that everybody would want to know in general. But all of the provisions, the reporting requirements, the gag clauses do apply to those entities as well.
Okay, and the other clarifying question that came up, does the reporting include the plan year 2022?
It will. This is going to be in perpetuity now. So they're starting with the plan year of 2020 and 2021 that's due in December of 2022. And then there are reporting requirements based on when your plan year starts that allow, I think, for an 18-month period after, so that it can capture those rebates and closing out that plan year.
Okay, great. Thank you. So now I am going to turn it over to Annette Garisco Files from ERIC for some comments.
Thank you so much. Debbie, that was a really terrific presentation. I look forward to Mike's comments as well, because he's in a unique place to understand the impact. So at ERIC, we did help formulate this legislation. The companies need to know how much they're spending on all aspects of healthcare, hospitals, drugs, you name it. And we don't always know, because the money goes into a big black hole. We know we spend it, but we don't know exactly what it's going to and how much we're spending on individual items, because they're aggregated. And so this legislation is a lot to digest, but as we get through it and we can see the data that we believe we should have been able to see for years, but haven't been able to get access to, we'll be able to help our employees make better decisions. We'll be able to save money for the plan participants as well as the plans themselves. So be patient, listen to Debbie's sage advice on how it is that you can comply. What I wanted to focus on is that this isn't the only aspect of transparency that we can focus on. And so later, I'd like to kind of talk a little bit about the Pbm transparency, maybe after Mike goes, and the things that we've been asking Congress to clarify. I wanted to point out just a few things regarding Gad clauses. There are a lot of unanswered questions about Gad clauses. And I'll put in the chat box in a minute a letter that we sent to the Labor Department asking for specific guidance. And I just want to point out some of those things to you all. We asked the department to clarify, so let me take a step back. For years, we've asked for this information. We large employers have asked for this information, and the PBMs and others tell us, well, they don't, it's not our data. We don't, just like with claims data, quality data, we can't give it to you. It's not your data. It's our data as an insurer or our data as a PBM. Now it's clear that we're entitled to this data. And so they've been hiding behind gag clauses. And now we've been asking the Department of Labor to clarify that the gag clauses are prohibited, starting with all contracts and contract renewals entered into after the date of enactment, which is December 27, 2020. So any 2021 contracts that the PBMs or others have entered into cannot have any gag clauses. We cannot have any gag clauses in any of those contracts. And so they're outlawed. So I think it's really critical to take a hard look at what you have and for us to get good confirmation from the Labor Department on the prohibition on gag clauses. Another thing that we've been asked to clarify is that the gag clauses are removed in time to allow the insurers and others to comply, in that the administrative service organization agreements, the administrative service only agreements, rather, the ACO agreements, also will have a prohibition on gag clauses, because we don't want there to be hiding behind any types of agreement. And that non-disclosure agreements between health plans and third parties are also prohibited under this legislation. And that was not clear from the guidance that we've received so far. So we've been asking for clarification on that. And finally, on pricing information, we want a gag clause prohibition on provider identifiers, billing codes, procedure codes, billed amount, and allowed amount, that all of that information can be given to us. And it is true that it's a big data dump, but the best way for us to know how we can manage our spend is to know exactly what we're spending. So I encourage you to take a deep breath and get with your trusted outside advisors and your in-house counsel and make a plan on how to comply. So Debbie, thanks for that great presentation. Maybe I should turn it over to Mike.
Yes, Mike.
This is going to be quite a year. This is an area that's been a pain point in the industry for as long as I've been in the industry. And Debbie mentioned, 2%, which she refers really to 200 basis points. That's what happened in the investment world when things actually got disclosed. 200 basis points. Can you imagine how much money that is? Went away. And in this area, if you look at that very first chart, if even half of that is true, you cannot justify how much money is being taken out of the system by the intermediaries that probably are not, you can't justify how much value they're adding that would justify that type of money. So with that in mind, I'm kind of setting it up a little bit. So as much as there's maybe too much being taken out of the system, I would also say that the other thing that there's a number of things that I think plan sponsors have to be conscious of. One is the system today has been built to maximize rebates, bottom line. And a rebate is not a rebate. So there's two facts you got to know. It's been built to maximize rebates, and a rebate is not a rebate. So when you're saying I get my share of the rebates, you get whatever's called a rebate. But that doesn't mean there's not other things that are contributing that other side of the pot, right? And you're gonna need a sophisticated advisor to ask the questions right and to keep pushing. And it's a little dangerous to say your intermediary will answer all the questions for you and you're all covered, because your intermediary is the one that you're effectively overseeing. So I think you're gonna need a trusted advisor, but not just any trusted advisor, because I'm trusted. You're going to need somebody who is very sophisticated in this area, because this is rocket science. This is complex, the way this has been built. And the definition of rebate is not clean. One thing to be aware, rebates operate with a lag. So if you look for a line item on your rebates this year, those rebates are from a year or two ago. It just takes time for the rebates to work through. And so that's why all this stuff is going to happen with a lag. But the other thing that I would be very wary of that people probably don't fully appreciate, and we found in a number of our analyses, is it isn't just the amount of money that's being taken out, it's the misalignment of the incentives. The fact that we are focused more on maximizing rebates than managing costs overall means that the drugs that are on formulary or the drugs that are preferred are often preferred because of the business models of the intermediaries, where they are making commitments years in advance as to how many rebates they will deliver on your behalf. And the way this was characterized by one of the advisors was, you're paying for your own rebates. The retail cost of these drugs is going up so quickly, in part to fund the rebate guarantees we have in our contracts. And PBGH, the Purchaser Business Group on Health, did a study a number of years ago. There are a number of drugs that should never be on formulary, but they are simply to generate the rebates, right? And so that all this misalignment. Then finally, the other hidden concern. So one is the players, and that includes your consultants and coalitions and others that are taking a little piece of something in here. Is what they're doing worth what you're paying them, whether or not you knew you were paying? Because now you've got to know that you're paying them, and is it worth that, right? And what's your alternatives, right? And then the other concern is, at the end of the day, can you justify having the gross cost be so much higher than the net cost at a drug level? The extreme of this is Part D. Part D, if everybody remembers, there's a donut hole. Well, effectively, people during the donut hole pay more than the cost of their drugs for the drugs. And that's essentially holding down the overall premiums. But that's also one of the big motivators to keep driving prices higher and rebates higher, because that's helping to stabilize the Part D engine. And Part D is where many of the intermediaries make most of their money on this. So it's a complex issue, but you've got to be engaged, and the time is now. The time is now. The good news is, at the end of the day, there's misalignment and there's margins that aren't warranted that can go away. And I think it's incumbent upon all of us as advisors, trusted advisors, to engage actively here and help to create clarity. My caution: don't hand the keys to the car to the people that you're overlooking. Overlook them with advisors that can ask smart questions and make sure you've got all the details. So I'll stop and let others intervene.
Thank you, Mike. As usual, really rousing us to recognize the importance of this, which is really important. Let's not forget, this is going to make a big difference in the positive for both employers and their employees. So before, we have really good questions, and from the audience, and I really want to get to. However, Annette, you did raise, I got interested in, you said that you're going to Congress and the administration on behalf of your employer members. You have some, you have an agenda of issues that you think still need to be addressed around this. Can you give us a little preview of that before we go to these questions?
Sure. There's bipartisan interest in addressing prescription drug costs in a thoughtful way. We need more competition. We need more sunshine. We need to see more. I was stunned at the beginning in the Debbie's pie chart with the $103 that it really was going back to the employers. It isn't clear that it does. Employers don't even know that it's 103. So what we need is Pbm transparency, so that we make clear by law all the rebates, no matter what you call them, as Mike so correctly points out, belong to the plan sponsor. So the plan sponsor can use them in a thoughtful, fiduciary way to reduce costs overall for plan participants. and not just to the particular person who happened to, use the particular drug. And so we need, so we've asked Congress, and we have legislation that's been introduced in the past and will be introduced again on a bipartisan basis, calling for the PBMs to give each employer a quarterly report that lists the cost, the fees, all the rebates, no matter what you call them, and passes on those rebates to the plan sponsors. And there's a whole list of things in the PBM area, including eliminating spread pricing, that we need to call on for the PBMs, and lots of other things in this space too that, and we could talk about if we have more time. But that's one of the top things on our agenda that we think could really overall increase drug costs.
Great. Well, thank you. Thank you for fighting the good fight also. We really rely on Eric, so it's very important to employers. All right, so let me ask some questions here. There's from our audience. Is there a website or process where employers post the numbers? So they're collecting all this great information. Where do they disclose it? Maybe Debbie, or you have some thoughts on that?
Yeah, so my understanding is that the government is still working out the machine readable files in that format and all those things there. I will tell you that the reports though are pretty simple enough that they could be generated now, and regardless of the ultimate format that needs to be filed, in our system, like I with the exception of the rebates, right, easily could generate those reports. And then getting the rebate dollars and showing the reduction in the premium calculation. So I said that the official forms and all of that, I think, are still being all vetted out, because I think that the PBMs, what I've heard, and I've spoke to one of the big three this past week, they're still working and trying to negotiate changing, because initially it had to be at an ingredient cost level, and they're saying, well, we want to aggregate it, and we want to do it by region, we don't necessarily want to do it by specific employer. And so that's what is being, so the official form isn't there, but again, that's the level of information is available today.
Because we have a number of questions about this issue of aggregating versus the code level data.
Mm-hmm.
Like if a PBM uses a rebate aggregator, will they have the rebate data will they have the data at the claim level? And then will they have to pay it at the NDC level if they only get it at the aggregate level?
Yeah, I'm unaware of any transaction that is not any rebate transaction that isn't specific to a certain drug. So just to give you an example, and we were saying about, generics don't get rebates in general, really it's the brand medications. And so if you have a brand medication and there is one that has generic alternatives, such as an inhaler, and then there's the tablet that is unique and it doesn't have any alternatives. If a person aggregates all of the drug together, like let's just say it's Humira, right? And they have the Humira pen, and then they have the QuickJet and all these things, right? So if they aggregate them all together, it kind of obscures and protects maybe with the individual syringe discount that it is. And that may not be a bad thing. However, when you get it to a broader class of drugs, it's just obscuring it to the point that you really don't know, right? Because today employers generally get aggregate partial rebate information. They get a check. They know they get a check, and they can show probably how they use that check to reduce planned expenses and premiums when they did their actuarial rates that they have. But I think what's being said is you don't know that check you got is based on the prescriptions that your plan utilized, and there's no auditing, there's no checks and balances of that. So aggregators will, number one, do have the claim level information, and they will have to report at whatever finalized decision the departments come out with.
So on some level, the department has not come out with a finalized decision that can give us all of the
Well,
on this.
Well, right now, the statute is written the way the statute is, and they said to start working on it now. And the statute says that you have to report the top 25 drugs by rebates. So
Okay.
how do you define a drug? They came out with clarity to say a drug does not have to be at the NDC level. You don't have to get to the tablet and drug strength and the drug manufacturer, but you do have to get to the ingredient. So you have to know if it's Humira, you get on Humira this rebate.
Okay. And then there's a question about 340B drugs and how they play into this. Let's see. Is any of the PBMs, health systems, pharmacies are making significant margins on 340B with very little flowing back to the benefit of the patient or plan sponsor? How does that play into this? Do we know?
Yeah, so, and Annette, I'm not sure if your conversations had talked about medical pharmacy. So just in the event that it wasn't necessarily clear to me in the statute because it says prescription drug. So prescription drug is generally a prescription you take to a pharmacy. So there is a whole world of medical pharmacy. 340B is one component. I don't think, because 340B is a different set of federal legislation that's really used in the simplest of terms to help hospitals and healthcare providers that service the indigent and poorer communities, the lost revenue they do on providing those healthcare services, they're able to buy drugs essentially at cost. So I don't think that those are part of this reporting requirement because one, it's exclusively under the medical benefit. And two, I'm not sure how those two legislations would work cohesively together. I will say though, one other question, since you're having all of these great conversations, right, that you could ask is the infused medications that are administered under the medical benefit, your oncology drugs, your Remicade is probably, everybody probably knows what Remicade is. It's used to treat inflammatory conditions that's infused. They get rebates as well. And so if the PBM, if you carve out your medical pharmacy and your medical specialty drug to be managed by your PBM, or even if you keep it with your TPA, there's still rebates being paid by drug manufacturers. And while it doesn't explicitly say prescription drugs, I would at least ask to make sure you're getting those rebate dollars as well, because I think in some future iteration that would be required as well.
That could be a very expensive oversight not to ask about that. I mean, that's a key aspect of medical spend.
Yeah, and I did see some clarification about the 340B being pharmacy and medical. I know that pharmacies can actually administer and bill the 340B. I know they have to keep their inventory separate. So yeah, I may be, whether or not it comes through under the medical pharmacy benefit and the members paying a copay, or if it comes under the medical benefit, I'm not 100% clear on that. But I don't see anything in the statute referencing 340B discounts.
Okay, we have a question about the gag clause issue in the contracts. If do you mean that the gag clause section of the contracts are voided, or does a new contract need to be created?
That's a great question. We've actually asked our ERISA attorneys because Innovu has, and I'm sure many of you have gag clauses in your contract. There are also provisions in a contract that say if future federal regulations override or make certain sections of this contract illegal, to put it very simply, then those portions of the contract would no longer be applicable. So we're actually seeking guidance from our ERISA attorney to say, does this protect us if we choose to ignore the gag clauses, or do we truly need to get a brand new contract with them removed? I don't know if any other panelist has, I don't know if any other panelist has experience on that topic.
That's one of the things we asked the Labor Department as I'm looking back on the letter, and I put it in the chat, that we asked the department to clarify when the gag clauses must be removed from the contracts. But it is true that federal law can override a contract and make something not enforceable. So I think the departments need to come out with guidance on this. They also have to clarify how they're going to say that we have plan sponsors have access to some information for purposes of this part of the CAA and not other information when we're getting into surprise billing negotiations. And so we're asking them to ensure that they enforce the measures consistently. Otherwise, we'll be whipsawed, which is not unusual in this space.
Okay, so a little bit more to come later on in this, but obviously you're all thinking about this. How do you suggest people push back if their TPAs and PBMs say they don't have the information, et cetera?
So one of the things that I'm just going to give an example of something that that I came across is when you ask it and they say they don't have it, actually get something from legal that is a written attestation and have them legally attest that they don't have it, they don't receive it. I think that generally, whenever something can be used as a document in the court and in the court of law, they generally try and get the answer a little bit that way. I mean, if they don't have it, is it that they don't bill any rebates? You know, you get no rebates. And if that's the case, they don't have it, then you may be paying a lot more for drugs than everybody else. Because I mean, the rebates are a tool used to manage some of the costs, whether you get 100% of it or not. Those inflated dollars are real.
Leah, I don't know. It just strikes me that part of the point of the CAA is the buck stops here, right? The buck doesn't stop at your PBM, it stops at you. You are the entity that is responsible to oversee your plan. And it empowers you, but if you are not getting the answers you deserve, then you are not partnering with the partner you should be partnering with. Because this is your data, this is your plan, and it's irresponsible not to insist on what you need to manage the plan. And historically, we've allowed intermediaries to get away with this stuff, and now the law has our back, and it's inexcusable for a plan sponsor to say, oh, if you don't got it, that's fine. Because there are plenty of PBMs in the ocean here, right? So it's not like you got no choice. You got lots of choices, and it's inexcusable, in my opinion, to allow the existing scenario to go on. And frankly, I think you got to be very careful, even with your intermediaries who are consultants who have a vested interest in the solution that you have, to rely on their algorithms because obviously they believe in their algorithms. They wouldn't be telling you. You've got to have some independence in exercising your fiduciary responsibility. And it has to be with people who don't have a vested interest in the outcome. And you've got to get into, you can't stress it enough. And, you know, people have been talking about in CAA more generally that lawyers are going to be lining up. Well, this is like shooting pigs in a poke. Everybody has a problem here. Everybody. Mm-hmm. You will likely get sued if you don't exercise your fiduciary responsibility, because it's not that hard. If you're being kind of indifferent, say, oh, I love delivering my rebate check to the CFO every quarter, you're probably most likely the one that's getting taken advantage of, and you don't even know it. So I know I'm on a, but this is serious stuff.
Michael, you brought up one thing too that I think is actually helpful in that, just real quick, is that the legislation actually has a different section that tells the steps that the plan is supposed to take, and that's with regards to reporting of direct and indirect comp. So if you consider rebates as direct and indirect comp, the steps that's outlined in the statute is you have to ask them in writing. They have to be able to give you a written response. If they don't give you a written response with 120 days, you have to ask again, and you have to report it to the Departments of Labor. If they still don't give it to you, you have to fire them and find somebody else. So use that as a template for your conversations.
Okay, well, that's a good way to end, because basically what this legislation is giving employers is a major problem and a huge opportunity to make things much better. and make your health benefits better for your employees and far more cost effective for all of you. So that's, I think, a very positive note. We have rich chat going on, great questions. We will be posting that along with a copy of the videotape of this and other, a great toolkit of 5 question surveys, coming to 5 questions that help us make sure we make this webinar the best it can be. So take a look at that. And leapfroggroup.org, you can get all of this information and any follow-up information based on these excellent questions and conversation happening in our chat. So thank you for being with us. Thanks to our speakers, Debbie Partsch, excellent presentation, great overview of this complex issue. And also to our great leaders among employers who have been so impactful in making this legislation happen, but also in making sure it works. Annette Garisco Files from ERISA Industry Committee and Mike Thompson from the National Alliance of Healthcare Purchaser Coalitions. I'm Leah Binder from the Leapfrog Group. Thank you for joining us.
Thank you.